Hello, hello. One, two, three. Hello. Mic check. Hello, hello. One, two, three. Hello, hello. Mic check. Hello, hello. One, two, three. Hello. Mic check. Hello. One, two, three. Hello, hello.
Hi guys, I request everyone to be seated down. We'll be starting off in 5 minutes. Hello everyone. Before we begin the inauguration ceremony, I would like to take a moment on behalf of the entire Nalsar community to acknowledge a deeply painful loss. We recently lost Mr. Sahasranshu Pandey, a cherished fifth year, a batchmate and a friend to many of us. His warmth, intellect and kindness left a lasting impression on everyone who had the privilege of knowing him. As a mark of respect to his memory, I request everyone to kindly stand and observe a minute of silence. Thank you. May his soul rest in peace and may we always remember him with affection and respect. Starting off, a very hearty good evening to our Honorable Registrar Ma'am, to Rohan Sir, esteemed professors, respected panelists, participants, volunteers, and all the other attendees. I'm Utkarsh Agarwal, and I'm the head of the organizing committee for this edition of the competition. And it is my absolute pleasure to welcome you all to the inaugural ceremony of 18th Justice Bodh Sawhny Memorial Moot Court Competition, which also happens to be Nalsa's flagship event and one of the country's most prestigious constitutional law moots. Over the years, Nalsar has hosted some of the finest India's moot court competition, witnessing the participation of brightest legal minds from across the nation. Continuing this proud tradition, we are delighted to present the 18th edition of Justice Bodh Sawhny Memorial Moot Court, organized in collaboration with the Justice Bodh Sawhny Memorial Trust and in association with the Vidhi Center for Legal Policy. Also this year, we are proud to announce that the BRS Moot Court competition has been made largely paperless, a significant first step towards greater sustainability and efficiency. While certain essential printed materials will still be provided when necessary, the majority will be accessed digitally with both judges and teams using tablets or laptops during the rounds. The initiative marks the beginning of Nalsa's continued efforts to integrate technology and sustainability into academic processes. It reflects our commitment to fostering innovation, adaptability, and environmental responsibility in every aspect of university life. So, the Justice Bodh Sawhny Memorial Trust was established in 1999 by the late Mr. Digambar Sen Sawhny in memory of his father, Justice Bodh Sawhny, an eminent jurist and a stalwart of the legal fraternity. The Trust strives to promote excellence in legal education, community health, environmental conservation, and the upliftment of women. Over the years, the Trust has collaborated with national law universities and law colleges across India, supporting scholars through scholarships and fellowships for higher education and legal studies. We would also like to take this opportunity to extend full gratitude to our associate sponsor, Vidhi Center for Legal Policy, for their continued collaboration. Vidhi is an independent legal think tank dedicated to strengthening India's legislative and governance framework through research and reform. Their association has enriched this competition with the spirit of intellectual depth and policy engagement. We are pleased to share that this year's edition continues the panel discussion introduced last year, which has quickly become one of the defining features of the competition. The discussion aims to foster rigorous engagement with contemporary legal issues, encouraging critical analysis and thoughtful dialogue among students, practitioners, and scholars alike, truly enriching the academic experience for everyone involved. We are also honored to continue the Nani Palkhiwala Award for Best Speaker, a prestigious recognition of excellence in advocacy. We extend our sincere gratitude to Mr. Homi P. Ranina and the Nani Palkhiwala Trust for their continued support in celebrating advocacy and legal acumen. This year's Moot proposition addresses a complex and deeply relevant theme, queer rights in India. It has been meticulously drafted by a team from Vidhi Center for Legal Policy comprising Mr. Alok Prasanna, Ms. Mayuri Gupta, Mr. Anshul Dalmia, Ms. Namrata Mukherjee, Ms. Kartavi Satyarthi, and Ms. Jwalika Balaji. The proposition gives participants a chance to explore nuanced constitutional questions and craft sound, well-reasoned arguments on an issue that continues to shape India's constitutional discourse. Without further ado, I now request our registrar, Professor Vasanti, to kindly address the gathering and share a few words with our participants and attendees. Professor Vasanti is a distinguished academic in the field of constitutional law and has been instrumental in designing and teaching several courses at both the undergraduate and postgraduate levels. She has completed her education at Osmania University and joined NALSAR in the year 2000. Over the years, she has contributed immensely to the development of courses in constitutional law, public law, comparative constitutional law. Her academic interests also extend to labor law, clinical legal education, and women in law. Before joining academia, Professor Vasanti practiced law for over 7 years at the Andhra Pradesh courts, which adds to her rich and practical understanding of the discipline.
Thank you, Utkarsh. Good afternoon, everyone. Let me join the BRS organizing committee in welcoming all of you to Nalsar University of Law. We take great pride in organizing this particular competition, and as the introduction would make it very obvious, it's obviously very close to my heart, being a premier constitutional law moot. And over the years, we have seen that the kind of questions around which the moot court problem has been framed have always been very thought-provoking. In fact, I remember from the last moot, the problem that was drafted was such that there were possibly no precedents that anybody could rely on. And it was deliberately set out so that everybody would push the boundaries of what they already know. And in coming years, delimitation, which was the theme for the last year, is certainly going to be something that all of us as constitutional lawyers or people interested in constitutional law will always have to engage with. So, along with welcoming all of you, I thought I would share a couple of ideas. One, of course, to thank the organizing committee for its tremendous effort despite all the challenges in putting this together. And also to the Bodh Sawhny Memorial Trust for continuing support, which makes this event even possible. But apart from that, just an idea as to why mooting becomes such an important skill in legal education and the continuing focus on mooting as an activity that all law students must mandatorily engage with is the idea that mooting allows you to look at certain problems which are perhaps not directly within your syllabus, but engages you, pushes you to know your own area and other areas also at the level of a particular instance, a particular problem. Rather than understanding law at a very generic level, mooting allows you to devote attention to the nitty-gritty, to the finer details, and pushes you to expand your own research skills, your articulation, the manner in which you are able to present an argument, as well as engage with the other argument. So that idea that there is no one side to an issue, which is what lawyering and advocacy is all about. To be able to say that, yes, there will be, if not too many sides to a particular issue. And I think that is a critical skill for lawyers, which I think mooting allows you to do. To always be able to appreciate that there will be a counter view and there must be a counterpoint of view. But not that a counterpoint of view is just a counterpoint of view, but a counterpoint of view has to be something which is well articulated and researched and challenges you as you're preparing for it. I would just like to add one other skill which perhaps is not highlighted enough, and I would genuinely want all of you to think about it carefully, which is that we usually confuse advocacy with argumentation, and we believe that, to be able to make an argument and to make a strident argument or to make an argument that is very forceful is usually the only argument that we are looking at. But I think the idea of presenting arguments in front of a panel to a person whom you are trying to persuade is not to browbeat that person. It's certainly not to say that you do this orals, right? So the idea of an argument building is to be able to persuade the judge to see your point of view. And I of course, this is something that I see a lot of the good mooters are always very conscious of it. But if any of you at any point of time have missed this finer aspect, that what you should be looking for is try and persuade the panel in front of you, not browbeat the panel in front of you, or present your arguments only in a forceful manner without trying to see where the panel is and what is the question the panel is asking you. So while making an argument is an important skill, it's equally important to listen to what is being asked of you and to be able to tailor what you know to the question that is being asked. And that, I think, is the most critical skill of advocacy that I would think that all of you would want to invest in, and I hope all of you have a wonderful moot court ahead. Thank you all again for bearing with us, understanding our difficult circumstances, and still making it. The moot court would not be possible without the support of all of you. So thank you again for coming down and participating in this. And of course, kudos to the organizing committee for rescheduling at such short time and putting in so much effort to make sure that this year's competition is conducted. So thank you again, and I wish you a very good moot court ahead.
Thank you so much, ma'am, for your inspiring words and sharing your insights and encouragement. So now as we move towards the conclusion of this inaugural ceremony, I also request Professor Vasanti to kindly light the ceremonial lamp and formally inaugurate the 18th Justice Bodh Sawhny Memorial Moot Court Competition. Thank you so much, Vasanti ma'am. Thank you so much, Rohan sir. With this inauguration ceremony comes to a close. I would like to take this opportunity to extend my sincere gratitude to our Vice Chancellor, Professor Sri Krishna Deva Rao sir, our Registrar, Professor Vasanti, and our Moot Court Committee Faculty Advisor, Professor Thomas, for their constant support and guidance throughout the organization of this competition. I would also like to give a special word of thanks to Mr. Chidambaram, PS, to Vice Chancellor, for his unwavering assistance and coordination. His support has been invaluable in making this event possible at such a scale. Last, but certainly not the least, I would like to express my heartfelt appreciation to the organizing committee for their dedication, teamwork, and tireless effort in bringing together the 18th edition of BRS Moot Court competition. The BRS Moot has been a proud legacy at Nalsar, and it is our sincere hope to carry that legacy forward with another successful edition this year. I request all participants to kindly stay back for a few minutes after the ceremony concludes for a short briefing regarding the device policy, campus rules, and cash orientation. Thank you all once again for your time, support, and presence. आपको जाना है इसको वापस चालू करना रहेगा लेकिन
Hello, check. Hello.
Hello, check. 1, 2, 3. Siri. Nope. Have you turned on your volume? Yeah? Still.
Hello. Hello, check. Hello.
Test, test.
hello guys. We'll be joined by the panelists shortly, so please call your teammates back. And just please be seated. Yeah.
Hello. Yeah. Good evening, guys. The panelists are joining us. Please take your seats. Good evening, everyone. I'm Prakul, and this is Vivek. On behalf of Nalsa University of Law and the organizing committee of the 18th Nalsa Justice Bodh Sawhny Memorial Moot Court Competition, it is our extreme privilege to welcome you all here to today's panel discussion on queer legal futures in a post-superior world. We are so glad to see this room filled with participants, faculty, and friends who care deeply about the future of equality, dignity, and inclusion in India.
This discussion is hosted in collaboration with the Vidhi Center for Legal Policy and sits alongside the 18th edition of the Justice Bodh Sawhny Moot Court Memorial Competition. Over these years, this moot has become a destination for rigorous constitutional conversations, and we're delighted that today's event continues that tradition by centering queer rights, policy, and lived realities in the wake of the Supreme Court's decision in Supriyo at Supriyo Chakrabarti versus Union of India case.
The Superior decision marked a powerful affirmation of dignity and of the realities that queer persons navigate every day. At the same time, it left critical questions open, especially around marriage equality, family recognition, adoption, healthcare access, and freedom from discrimination. It also called for a high-powered committee to outline benefits that should accrue to queer couples and to identify areas requiring urgent state intervention. Today, we interrogate that in-between space, the promises made, the gaps that persist, and the pathways, legal, legislative, or social, through which we can move closer to substantive justice.
Our aim is twofold. First, to take stock of the current legal landscape, what has changed put Supriyo and what has not. Second, to look ahead. How can constitutional values of equality, dignity, and non-discrimination be translated into real outcomes? What roles will litigation, legislative reforms, and grassroots mobilization play? And how do we ensure these strategies talk to one another rather than work at cross purposes?
A special word of thanks to our partners, the Bodh Sawhny Memorial Trust and Vidhi Center for Legal Policy, for their sustained support, to our faculty advisors and the organizing committee along with the volunteers, and especially to all of you for showing up with such eagerness. Events like this only make sense when they create a space that is brave, respectful, and grounded in the experiences of the people most affected. Now, moving on to our panelists for the evening. We are honored to be joined by Assistant Professor Satyaprasun from Nalsa University of Law, whose scholarship and teaching probe constitutional structure, rights, and the everyday workings of the state. His teaching and research engage deeply with constitutional law, anti-discrimination, religious freedom, and questions of constitutional identity. He holds a BA LLB honors degree from the West Bengal National University of Juridical Sciences and finished his LLM at the University of Melbourne. Sir writes and speaks extensively on constitutional culture and governance, contributing to academic discourse through his research and public interventions. Secondly, we have Dr. Saurav Mandal sir joining us. Sir is an associate professor professor of law at General Global Law School, Sonipat, where he also serves as the associate editor of the General Global Law Review. His work explores the intersections of law and society, gender, sexuality and governance, and global queer movements and law reform. He has held visiting positions at Georgetown University's Center for Transnational Legal Studies in London and has served on the school board of the School of Gender and Development Studies at IGNOU, New Delhi. Sir also holds a PhD in law from NLSIU Bangalore, where his research examined the impact of family jurisprudence on queer lives in India. Sir is also a former Felix Scholar. It's a pleasure to have you with us, sir.
Thirdly is Miss Advocate Raghavi Shukla. Raghavi Shukla is one of the first openly transgender lawyers practicing in the Supreme Court of India, as well as in various courts and tribunals across Delhi. She graduated from Campus Law Center, Delhi University in 2023 and works extensively in the area of LGBTQ+ rights. She boldly called out the shortcomings of the 2019 Transgender Persons Protections of Rights Act, highlighting how it forces transgender people into a system that treats them as a lesser rather than empowering them to live freely. Lastly on the panel is Ms. Kartavi Satyarthi. Kartavi ma'am is a senior resident fellow at the Vidhi Center for Legal Policy. She primarily works on providing legal and policy research and drafting assistance to central and state governments. She works extensively in the area of gender and sexual laws and has worked on the Model Code of Indian Family Law, published by Vidhi as a comprehensive gender-just model of reform family laws. She also worked on recommendations for reform submitted by Vidhi in the high-powered committee formed pursuant to the Suprio judgment. Thank you all for being here and lending us your time and insight.
To frame tonight's discussion, we propose 3 guiding questions that our speakers may choose to engage with in any order. Firstly, from rights to remedies. Post-Suprio, where do queer couples and families still encounter legal dead ends, whether in marriage registration, adoption frameworks, social security benefits, housing, healthcare, or documentation? Which pathways, statutory, regulatory, administrative, are most immediately actionable? Secondly, institutional design. The court envisaged a high-powered committee to identify benefits and required interventions. What should credibility, transparency, and participation look like in such a committee's design? How do we ensure it is not merely consultative, but outcome-oriented and with timelines, metrics, and follow-through? Lastly, beyond the courtroom, where can local governance, private sector policies, universities, and professional bodies move first? How might targeted changes, say, in hospital protocols, tenancy practices, workplace benefits, or university regulations deliver material relief even as a bigger legislative questions evolve? We also hope that the discussion will touch the intersections that are often ignored, how caste, class, religion, disability, and migration status shape access to services and protections for queer persons. If the constitutional promise is universal, then the design of remedies must be attentive to difference. And while we ask difficult questions of courts and the state, we must not forget the role of legal education and law schools. Curricula, clinics, and campus policies are living laboratories for the futures we want to see. If we can't practice equality here in hostile forms, health center protocols, name and gender markers, grievance processes, then our constitutional vocabulary risks becoming performative.
So guys, just a few ground rules. So this is a space for listening across differences. So please keep your phone on silent and please be mindful. Your photography is fine, but please be mindful of others' comfort as well. The structure of the evening is pretty simple. We will invite each panelist to make their opening remarks. Then we'll move to a short round of moderated conversation. And then we'll close with audience Q&A and final reflections. So at any point, if a point resonates with you and you'll want to share the resource, please note it down. And during Q&A, please feel free to briefly mention any concrete proposals or examples from your own institutional context as well. The more solution-oriented we are, the more useful tonight will be. So we look forward to an insightful discussion, and I call Mr. Professor Prasoon to open the discussion.
Good evening, everyone. My name is Satya Prasoon, and I'm a faculty at Nalsa University of Law. Thank you very much for inviting me to speak on the panel discussion on Afterlife of Supriyo. The philosopher Avishai Margaret, in her book The Decent Society, argues that a decent society is one where the institutions do not humiliate people who depend upon them. To act decently makes a bare minimum demand on the society to treat its members as human. Therefore, a decent society will protect minority groups from all forms of discrimination, especially the ascriptive grounds forming identities. It protects liberty from non-interference and prohibits such inequality that injures the dignity of a person or causes humiliation. On the other hand, justice is a higher ideal. While aspiring norms of a decent society is the baseline for a community with rule of law based on equal worth of humans, the Rawlsian society starts as a decent society at first and moves towards a just society by focusing on securing basic conditions of living, ensuring equitable distribution of resources to enhance capabilities and opportunities for a fulfilling life enriched by liberty and equality. However, the fight in Supriyo was not about securing positive liberty and a right to marry or a just society through marriage equality, but the forging of a decent society where queers are not robbed of human worth and community living. The court, acting as a bystander while the humiliation continued, led down the community. The court misframed the issue, misapplied the precedent, and ceded its power of judicial review to botch up a fairly easy challenge on the terrains of constitutional law. I point to 5 instances of such misframing, misapplication, and judicial ceding in the judgment in my remarks, majorly focusing on Justice Chandrachud's opinion to critique the reasoning of the court. First, on the issue of framing, it is unprecedented that the inquiry into the right to marry claim led to abandonment of fundamental right to non-discrimination. For example, if women are denied property rights, will the court ask if there exists a fundamental right to property before testing claims of discrimination? Or should it test the legislation against the fundamental right to gender non-discrimination? Similarly, if a hotel denies entry to a person on caste identity, will the court ask if there is a fundamental right to enter the hotel to decide discrimination challenge? Unfortunately, the import of this judgment is that a successful challenge to anti-discrimination, a successful challenge of anti-discrimination is contingent upon demonstrating that the denial or the exclusion pertains to a fundamental right, or else the court is helpless to address statutory discrimination. Second, on the issue of interpretive misapplication, the court held that the complex act of reading in or supplying words to include queer or non-heterosexual partners under the provisions of SMA would amount to judicial legislation. This was the deja vu moment in Supriyo, rehearsing the non-interventionist reasoning in Suresh Kaushal. Even this interpretive attitude is outrightly wrong. Balancing the judicial review function with the presumption of constitutionality leaves the court with 3 legitimate options if the law is found to be unconstitutional. First, reading down or reading in words to the legislation to make it consistent with fundamental rights. Second, declaring the law unconstitutional on a future date or a suspended declaration of invalidity if the parliament does not amend the law to harmonize it with fundamental rights. This was the approach of the South African Constitutional Court in the Fowrie case that legalized same-sex marriage. Lastly, to declare the law unconstitutional if severability or addition is not possible. The third instance, and a rather baffling one, is that Justice Chandrachud never tested Special Marriage Act or SMA for violation of equality and non-discrimination due to the court's inability to give relief. The principle of judicial review to first determine the constitutionality and then fashion the relief was inverted in this case. The inversion was on two reasoning. One, striking down SMA will lead to a vacuum for interfaith couples. And second, supplying meaning to harmonize it will amount to judicial legislation. This was severely unsettling as the fundamental right challenge was evaded due to the court's professed inability to give relief. However, Justice Chandrachud's refusal to strike down provisions of SMA on the ground that it would create a vacuum for marriage registration of interfaith couples, combined with his observation that addressing discrimination claims against queer cannot come at the cost of perpetuating another kind of discrimination against interfaith couples, needs unpacking. And this is my fourth criticism. This points to a big deficiency in the anti-discrimination theory, where it rightly sees all discriminations as wrong, but fails to comprehend that not all discriminations are the same kind of wrong. Discrimination which reduces humanity of a group in a particular spatial context, like religious discrimination or gender discrimination, is nonetheless wrong, but less severe than the reject status that is produced, where humanity is rejected by treating Dalit bodies as repositories of filth and queer as objects of disgust, as their presence seem to undermine the constitutive norms of the heteronormative society to which the discriminator is attuned to. Creating a vacuum might have moved the state to fill the vacuum immediately by creating an inclusive statutory architecture to include interfaith same-sex couples for marriage. To contextualize this, think about this scenario. If we come across two individuals who are drowning, where one can swim barely to survive, and the other doesn't know swimming and will drown if not saved, the moral duty of saving a life is to first save the drowning person. The choice between saving interfaith couple from temporary discomfort by disregarding the drowning queer community presented such a scenario before the court. Lastly, Justice Chandrachud's last-ditch attempt at opening the door for queer community by recognizing a right of civil union to queer community was rightly rejected by the majority. However, my reasons are rooted in dignity and not separation of power as held by the majority. Recognizing civil union opens the door for a series of benefits analogous to a heterosexual marriage, but this would have been the Plessy versus Ferguson moment that gifted the unfortunate jurisprudence of separate but equal. Suprio was about the baseline struggle of queer community to be recognized, treated and accepted as humans by the institutions, state and society. It is about dignified treatment that is owed to every human in the society, and not the outcast status where there exists two worlds, the Brahmanical and the Dalit world, which don't interact but exist parallelly. Suprio was about demanding respect or extracting respect from a homophobic society and the institutions that tolerates them, while scoffing at the possibility of queers reclaiming space and performing their status as humans. It is worth reflecting who wants to ghettoize, who is blocking the pathway to legal marriage, who sees queer relations as against the order of nature, who fears intermixing and integration, who wants a separate world. It is the heteronormative matrix of state and society as argued by Butler. Therefore, the question before us is this: who should accommodate and cede ground in pursuit of a decent society? The refusal of Mahatma Gandhi to deboard from the first-class train compartment in South Africa, or the movement forged by Dr. Ambedkar for temple entry or to drink from public wells, were not for securing a seat in a train or seeking a place to pray or any well to drink water. It was about fighting segregation that treated Gandhi or Ambedkar as subhumans, and thus the fight for securing the same public resources as the discriminator and on the same terms. Commentators have remarked that Suprio was a missed opportunity to apply the non-discrimination guarantee to march towards a more decent society. However, I disagree with this, and I argue that the eclipse of non-discrimination guarantee was expected due to the flawed and inept logic of anti-discrimination theory. Anti-discrimination law in India is based on the principle of immutability or effective immutability. This means that certain identity characteristics or choices are protected from adverse targeting on the ground that the targeted person does not have an effective choice or a choice in real sense. Therefore, it would be immoral to target that person for such a deviant choice. The heteronormative society adopts a morality of blamelessness or benevolent forgiveness in allowing liminal protection, as the unfortunate individual does not have a choice in real sense to abandon that trait, as it could not be changed or could only be changed with much psychological or emotional pain. This has meant that despite protection from discrimination, think about it, of all the identities that are protected under discrimination law, those targeted are still seen as deviants and their choices as deviant choices. And the discriminator conduct continues to be the norm. Due to the protection being based on blamelessness towards the targeted, the discriminatory conduct or the attitude based on majoritarian heteronormativity remains intact. The logic of immutability undergirding the anti-discrimination theory plays out by protecting the status or identity, but ironically punishing the performance of that status or identity. The phenomenon of covering of identity ensues because the societal lens announces the toleration of homosexuality as long as one is not openly homosexual. It is as if the larger society is telling you that they would tolerate a person who is gay as long as that person is not openly acting out to be gay. The theory fails to understand that discrimination does not lie in labels, but in the social meaning attached to the labels. With time, despite protection under anti-discrimination law, the social meaning attached to the labels gets even more entrenched in heteronormativity. The bottom line in Suprio was this, that the state and the society was not ready to accept the queer people into the venerated institution of marriage. Rest of what followed was very sorry legal gymnastics that played out in judgment to cover up for the stigmatization and prejudice festering the institutions and the larger society. Suprio vindicated the limits of anti-discrimination theory to allow queers to exist on the margins as long as they don't act out their status as queers. The downslide from Navtej to Suprio is the court's way of warning the queer community to choose covering before entering the heteronormative society. Thank you.
Thank you so much, sir, for sharing your thoughts. Now I request Ms. Raghavi to share her thoughts as well.
So, hi everyone. I'll keep it short. I'll start with three things that I basically want to talk about. First thing is that how we, before the Suprio movement came, how before that the strategy seemed to be flawed. Second thing that I want to talk about, that how be it litigation, be it policy, how they are divorced from the idea of care. And third thing that I wish to emphasize on, that how we need to. So with Suprio, the expectation was that once you get the right, once you get the recognition of the union, then there will be a bundle, a bouquet of rights that will come along. What I also want to emphasize, and what I also want to talk about, because queerness, the idea of queerness is very different. And my problem has always been that there have been attempts, and we are doing it, to imitate the cis hetero idea of society, the cis hetero idea of relationship, the cis hetero idea of union. And my problem precisely is that why only a specific person who happens to be my partner gets to sign my hospital form, or a certain person I can open my account with, or a certain person gets the rights because they happen to be my partner. Why it cannot be someone from my chosen family? So these three ideas broadly that I want to emphasize on, and I think at the core of it is something that I strongly feel in, which is dismantling the idea and the institution of marriage itself, because it is a very casteist, it is a very patriarchal setup, and we have seen it. Now, I think once we start the panel, my emphasis will largely be that I talk along these aspects, along these lines. And since we are short on time, I believe, I think I'll just let the other panelists also make their comments. Thank you, guys.
Thank you, Ms. Raghavi. Now I invite Dr. Saurabh Mandal to share his thought as well.
All right. So guys, right, I think I'll just, how much time do I have? It's fine? Okay, all right. This time, yeah. So a couple of points. So I think the theme is aptly put as the queer legal futures in a post-Supriyo world, and as my colleague, Professor Prasoon, has aptly pointed it out, that it's the afterlife of Supriyo, if it has an afterlife. Clearly there is a life after Supriyo. Whether Supriyo has an afterlife or not, and to what extent that is Supriyo's afterlife, is what we need to see. This is a judgment about nothing. I mean, as you can see, this judgment doesn't give any relief that is sought from the court. The court has been absolutely disappointing to the queer community as such. I used to be a fan of sort of more, I used to be sort of more on the theoretical side of the things at one point of time, but I think now as you grow a bit more, into the things, and things grow into you, you kind of get more on you kind of expand your horizons a little. So I think, look, marriage is not going to go anywhere, right? As a matter of fact, let's understand, when I wrote my PhD thesis in 2016, 17, at that point of time, my argument was essentially that contract has to substitute, or contract has to create a parallel regime of family, right? A family based on idea of cohabitation contract. So my thesis was essentially that, in my PhD thesis, I don't stand by that argument totally now anymore. I have modified that argument over time. My argument back then in 2017 was that in the Indian Contract Act, you have got a freedom to contract, right? And you're free to choose a partner of your choice. And if you read Ruth Vanita, one of the oldest, one of the first queer literary scholars in India, and I read her book back in, I think, 2009, or I think 2006, 6 or 7. That was Love's Right, Ruth Vanita's first book, and then the second book came up with Salim Kidwai. So Ruth Vanita is a professor of English literature at Monash University. And Ruth's book is sort of, it was an eye-opener. I was a law student at that time in the second year, third year, And so I read about in Ruth's book, for the first time I came across in my second, third year of law, that there's something called as Maitri Karar. Maitri Karar is something very common, very culturally embedded in Gujarati societies, many Marwari societies. Maitri Karar is a sort of a agreement of cohabitation, essentially. Then you figured out, during my family law classes at National Law School, I figured out, this is also importantly a subculture in Tamil Nadu. And it's very patriarchal. Men in Tamil Nadu, or many Tamil communities, not all, but there are many Tamil communities, mainly upper caste communities, where the man of the house has got a smaller house, a chinna vidu, right? A smaller house. And that smaller house has a smaller family, or a family, right? And that family is a form of unmarried cohabitation, right? That second wife is socially recognized as a second partner or as a second wife, but legally is not a second wife, because Hindu Marriage Act prohibits bigamy, if you see that, right? So technically that's how things are. And the tribal customs under Hindu Marriage Act Section 2, subsection 2, I mean, if you see the exceptions to Hindu marriage or Hindu laws, tribal rules also do not allow bigamy, so to speak, right? And I mean, this whole idea of exception to Hindu law is also sort of very guarded by the public policy. And that public policy is apparently heteronormative. It is heteropatriarchal policy, right? Now, look, marriage is not going to go anywhere. That's just as simple as that. My PhD thesis back then was that Indian Contract Act can be mobilized to rescue, to salvage the queer communities to an extent. When it comes to this urge to have a legal recognition of your families, why not look at the Indian Contract Act? What's wrong? Section 10 of the Indian Contract Act is very clear about, the contract should be legal at the end of the day, right? Is there a law in India that prohibits cohabitation? There is no law in India. In fact, the Supreme Court has almost created a right to cohabitation. If you look at, at least before the Supreme judgment, if you look at the judgments like, for example, Shakti Vahini versus Union of India, the 3 judges bench Supreme Court judgment, where it gave proper guidelines. Lata Singh's case, so many other judgments. And then very recently, the last year, Devu Nair versus State of Kerala. That's another important judgment for same-sex cohabitation. Supreme Court has clearly given guidelines to save, it has clearly given guidelines to the government of the state and government of India to protect the welfare, protect the interests, and to safeguard the interests of the cohabitees. Same-sex cohabitees in the case of Devu Nair, that's a recent thing, and for cross-sex cohabitees or opposite-sex cohabitees in the case of Shakti Vahini, right? So these are now 2 strong judgments that we have where Supreme Court has clearly issued guidelines to the respective governments to prevent honor crimes against cross-sexual couples. Mainly honor crimes happen in the name of caste or faith. Intercaste marriage, intercaste love, intercaste or interfaith love, mainly, the couples who kind of engage in intercaste or interfaith love, they are the ones who are targeted by honor-based crimes, right? Now, so Shakti Vahini judgment clearly cracks down on that. For same-sex cohabitees, it is this judgment, the Devu Nair judgment, right? That comes heavily. Now, Supreme Court has already partly protected the rights of mixed gender couples. At least transgender persons who are in a heterosexual relationship can marry under the personal law and also under the civil law. This is as per the Supreme judgment, right? This is as per the unanimously agreed, 5 judges have agreed on transgender marriages to the extent that they are in a heterosexual relationship. Again, this comes with the idea of conjugality. Again, this mirrors and replicates the idea of marriage. Marriage is conjugal. There is an element of sexual intercourse, right? Conjugality. There is an element of dyadic form, like there are 2 people in the relationship, not 3, not more than 2, right? So anyway, the idea of family is again very heteronormative in that sense, but at least now if you're replicating or if you're extending marriage, right to marriage, Supreme has extended right to marriage or rather queered marriage already to an extent. Now, so if you look at the Indian Contract Act, there is nothing wrong. I mean, cohabitation per se is not a crime. It's not an unlawful activity. It's not against public policy. You might say that it might be against public policy to an extent if some weird arguments are to be made, like about, if it's anti-Western and blah, 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 which the Supreme Court has already dispelled, have called them as myths in the Supreme judgment. There's nothing anti-Western. There is nothing Western about same-sex love. And take Navteej Jauhar judgment, take this one, Supreme. So Section 23 of Indian Contract Act really doesn't block the idea of freedom of cohabitation contracts, Maitri Karar. Take Section 25. In my opinion, Section 25 is another roadblock. Now, Section 25 of the Indian Contract Act is basically the provision about that you cannot enter in a contract with a person based on a relationship of love, right? Where consideration has to be in the form of some monetary form. Consideration cannot be based on love. Yeah, I mean, you have to have some monetary form of consideration. So maybe that is one area where we need a bit of, an argument. We need a bit of a case law. Well, if you look at case law, courts have allowed contracts between close relatives. But blood kinship is a factor. The courts have recognized that if a contract is between a father and a son, or between two brothers, they have recognized such forms of contracts, even if the consideration is actually nothing monetary, nothing material, right? So this idea of materiality of consideration has been sort of bypassed, and Section 25 has been sort of relaxed in that sense, if you see that. So now Section 25's interpretation is a bit more about a judicial interpretation. If you can overcome or bypass the Section 25 issue in a court of law on queer cohabitation or cohabitation in general, cohabitation contracts, enforcing cohabitation contracts in a court of law, then I think there is a way forward. But there's a problem with cohabitation contracts, and which is where I couldn't foresee this during my PhD days. I couldn't foresee this. Look, if you compare Indian family law with England and Wales has a very similar family law framework as India. They have, although, got an anti-discrimination law in the form of Equalities Act 2010. They have, although, got a, which we don't have. We don't have an anti-discrimination law in India, right? Unfortunately, they have it. I mean, and much because of the European Union and much because of them being under tremendous court litigation pressure, right? From ECHR and other, and their own Supreme Court, right? Anyway, so they have also got changes in their family law. Civil Partnership Act 2004 now allows, earlier up to 2019, Civil Partnership Act used to allow only civil partnerships between same-sex couples. Now it allows partnership with opposite-sex couples also. After 2019, the amendment has come because, again, of a judgment of the Supreme Court in 2016. The Same-Sex Marriage Act in 2013 extended marriage to all same-sex couples, right? And anyway, opposite-sex couples were always able to marry, right? Now opposite-sex couples can also enter into civil partnerships. So basically now it's a more equal regime when it comes to family law. But England and Wales's family law is much like our family law. You might wonder how. They don't recognize unmarried cohabitation, just like us. Whereas if you just cross the border of England and go to Scotland, they recognize de facto relationships. De facto relationships. That is, this law, Family Laws Act, Scotland Act 2006 recognizes de facto forms of family. So if two people are in a cohabitation for the last 6 months, they recognize that, yeah, this is a decent enough time. Minimum period is 6 months. You have been cohabiting for 6 months. That's fine. We will recognize you as a family. Australia has a very similar format. Most of the Australian states have slight differences, but Australian law is usually about 2 years, right? They also recognize de facto cohabitation. Now that's basically, de facto cohabitation is a form of legal recognition of what? Families, at the end of the day. You don't need to marry. You don't need to have a contract. You can be recognized by virtue of the fact that you're already cohabiting. So it's a more functional form of family. That functionally you are a family, you don't need to have a form. You don't necessarily need to fit into a form. You don't necessarily need to get into a marriage or fit into a civil partnership. However, I mean, this whole idea of cohabitation also has some limitations on it. For example, prohibited degrees of relationship, that is there. Conjugality is there. Yeah, dyadic, only 2 people, not more than 2. That is there. So it has some form element to it. We cannot deny that. Now, England and Wales and India have a classic story that their idea of contractual obligations, I mean, what they have done is their unmarried cohabitants, because there is no legal framework for regulation of unmarried cohabitation, their child maintenance law is very equitable. That applies to children, all children, married, children of married parents, unmarried parents, it doesn't matter. How much time do I have? Khatam karu? Acha. So I'll just take 2 minutes. Okay. So their marriage law is, so basically their child benefit laws are very, it applies across the board. But when it comes to, those rights, especially when a couple, unmarried couple, same sex or opposite sex, when an unmarried couple breaks up, right, breaks apart, now they want to end their relationship, or they have already ended the relationship, now they want property, claims on property. The litigation goes to the court. The courts often apply law of trust. The courts often apply law of contract, law of property, not family law. Family law works in a very different in a much more humane way, right? equitable distribution of property, fair distribution of property. Property is also given to those who have not contributed to the property, who don't have an official title on the property. But if you are going under family law, if you are a married spouse, your non-material contribution, your non-monetary contribution to the family is also taken into consideration. Okay. So, but these unmarried cohabitants are forced to go litigate under contract law, property law, trust law. So that's a problem. So what they have, in England and Wales, what now law firms or lawyers suggest unmarried cohabitants for the last 10, 15 years is that you sign contracts, cohabitation contracts, you design your own terms and conditions, and if need be, litigation has to be avoided or could be avoided. You can do out-of-court settlements and things like that and distribute property. You know, that way you can save. So in India, why can't we sort of have that kind of a format? I'll just end on this one note that marriage is not going to go anywhere. UCC has muddled it even more. UCC is UCC of Uttarakhand. I mean, the Uttarakhand UCC, okay? That's the only UCC we have. It could very well be replicated in other BJP ruled states. Gujarat already has appointed the commission on this under the same judge, Ranjana Desai. Assam, I'm told, is considering it very quickly. Other BJP ruled states might just go ahead with, you know, and that means what does Uttarakhand UCC, what has Uttarakhand UCC given us? 4 things. It excludes cohabitants, it excludes, I mean, live-in relationships it recognizes, but not same-sex live-in relationships, not legal non-binary individuals, right? So even what Suprio judgment gives the right to marriage to transgender persons in a limited way, it doesn't even do that, right? So that's a problem. Second is, it doesn't safeguard, I mean, it literally puts the right to choice, right to privacy, right to safety of all couples in a very bad way, because you look at the conditions. There's a lot of surveillance on, you know, I mean, on the gay couples or on any couples, sorry, heterosexual couples. There is a failure of, the Uttarakhand UCC to also prevent honor crimes. Right, there is a sort of a constant possibility of state surveillance on interfaith couples, intercaste couples. If you look at the way the law has been framed, you're also prosecuted. I mean, it's criminal. It's a criminal act to sort of you could be imprisoned if you don't register your partnership within 3 months of January 2025 when this law was enacted. You know, so I mean, it's weird. It's a very different kind of a draconian law. I mean, so if you're going to replicate this model, then I don't know. I mean, all the talk on the theory of that marriage must go off, you know, and that is fine. I'm totally for it. Totally against marriage. That's there. But is it politically possible in a kind of ecosystem that we are in at the moment, right? And for the next, I don't know how many years will we have to endure this political, you know, thing. Southern India is a little better, right? I'll end. Thank you.
Thank you so much, Saurabh, for sharing your thoughts and personal experiences. Now I invite Ms. Kartavi to share her initial remarks as well.
Hello, hi everyone. I'm Kartavi. I'll just do a short set of opening remarks and then jump into the moderated discussion directly. Does that work? All right, so we are on October 10th today, which is like almost 7 days away from marking the 2-year anniversary of Suprio. And we agree that while it's not a happy judgment, but what I will say that it is one of the inflection points in the journey of queer jurisprudence or laws in India that is happening. So a lot was happening before that, and a lot has happened, but a lot has not happened in the 2 years since Suprio. So again, speaking to the theme of the panel, we can have a look at what has happened in the past 2 years and how do we look forward to this? How do we look to the future? So one of the major developments was that the HPC, the high-powered committee that was mandated as part of Suprio, was formulated with a bunch of issues that were directed to the HPC. We have, as Dr. Mandal pointed out, a UCC now in Uttarakhand on the subject matter of family laws and relationships, which again, we will of course discuss this further, which governs relationships which are different from families, including live-in relationships, but there are a bunch of issues with that also. But initially it was looked at as one forums or fora where a little bit of recognition could be seen for a different form of family structure. Then there are of course several Supreme Court and High Court judgments that have come out since then. 7 states have issued transgender rights policies. But also the union government has, for the first time, given some clarifications like recognizing a queer relationship for the purposes of opening a bank account, for the purposes of a ration card. These are some developments due to which I would say that it is a little bit of an inflection point. But in terms of the future, there are primarily two routes, I would say, that have emerged or that we see. One would be the strategic litigation route, where since Supriyo was talking about a bunch of issues, there was, of course, marriage equality, but it opened up Pandora's box of issues that are persistent in terms of discrimination to access to goods and services, in terms of education, housing, the violence faced by members of the community, in terms of access to healthcare and the treatment meted out while accessing healthcare. And a bunch of issues did come out of Supriyo. But all of these issues can have individual value and they can be taken up separately in their individual right and in their individual manner. So that is one strategic litigation route that, of course, is might also be being pursued right now. Like the Kerala High Court has a couple of judgments. There is a taxation law case that is pending in the Bombay High Court, a petition that is pending in the Bombay High Court. The other route is to change political advocacy, political thinking of the electorate, linked to societal change, yes, but within the law also a little bit of political change, finally leading into some legislative action, which is where, again, the Supriyo put the ball in the legislative sphere, in the legislative action sphere. And of course, a lot of argument comes from the society that this failed maybe because, and it is still failing in terms of legislative sphere, because the society is not maybe ready for this yet. But again, there is a counter argument to that to be made, that the society might never be ready. The society was not ready at the time of the Hindu Code Bill. The society was not ready at the time of the Special Marriage Act. The society didn't want intercaste marriages, interfaith marriages. There was no way of recognizing these in personal religious laws. So yeah, the society might not be ready, which is why there is a case for that kind of advocacy shaping up legislative action. And then again, going back to the marriage equality case, there, yes, marriage equality is important, and yes, of course, recognition of relationships is very significant. It comes with a bundle of rights and entitlements, the right to succession, inheritance, the right to access spousal benefits under labor and employment laws. There are a bunch of rights and entitlements, taxation benefits under taxation laws. If you gift your spouse something that is not taxable, while it might still be taxable if your partner is not in a heterosexual relationship. So yeah, a lot of things, a lot of bundle of rights. And again, there is a argument that comes from that these rights and entitlements should be inherently delinked from marriage. What does marriage have to do with my right to make decisions for my partner, for healthcare related decisions for my partner, or my right to be able to access their dead body in a way, which was again a Kerala High Court case recently. My right to inherit from my chosen family. So yeah, taking from that, I think we have Dr. Mandal has also spoken, touched upon the UCC. I think let's jump into the moderated discussion, and I would take it to Professor Prasoon first. As I said, the UCC was initially being seen as maybe one alternative or one route through which we could reform family laws and relationship related laws holistically, and therefore make a little bit space for some queer recognition or recognition of atypical families. But there is also an argument or a worry or a concern that comes up from quarters that in itself UCC might be an erosion of religious personal laws or religious personal freedom under the Constitution. So I would like to learn from you, Professor Prasoon, how the two rights, the one being the right against discrimination, which is of course fundamental, interacts with this right of personal freedom or religious personal freedom.
Thank you, Kartavi. I think my response is that I am very suspicious of any statist attempt at creating a law which will provide for a bouquet of rights and another statute, for the very simple reason that if we look at the concept of UCC independently, even in context of personal laws, there has been not one serious thinker who has placed their weight behind UCC for the obvious reasons that the problem is not uniformity of laws. The problem is not non-uniformity of laws, but the problem is inequality that exists in the law. So this attempt at homogenizing the practices will come at the cost of not just minority religion, minority culture, minority practices. The default norm would be majoritarian. And here, when it comes to recognition of rights, then people who have written on legal pluralism would understand that if the society that we are living in, if social pluralism is a reality, then one will have to be comfortable with legal pluralism. Here also, on the possible conflict between religious, the possible erosion of religious freedom if we go for uniform civil code is a grave concern, for a simple reason that when you look at it in context of intersectional identities, it should not come to a point where a person will have to abandon something that a personal law practice that for them has theological origins for someone to decide if they want to enter into a union and register their marriage. Because even if one asks any queer persons, maybe there are multiplicity of identities that are playing out. So I am very suspicious of this attempt, also because the government that is doing it does not bolster confidence for the past that it has, that those states talking about gender justice and seeing UCC as a way to achieving that is something that makes me quite nervous.
Of course, the question of queer rights cannot be divorced from existing issues like women's rights, but also something that we have realized and experienced in our research is like if we sit and reform each and every personal law holistically from a gender lens, from a different, any kind of equality or dignity lens, what we end up with is a similar thing which looks similar to one another. There are a lot of finer nitty-gritties that get eroded. Of course, it borrows from different existing statuses of personal law, etc. But of course, there is a certain need for diversity to be retained. And again, diversity in faith and in diversity in family structures and atypical family structures. I would take that to you, Dr. Mandal, then. There, of course, are a number of atypical and traditional family structures that exist outside of marriage that have always existed in India, outside of marriage, and outside India also, outside the folds of marriage. And again, especially for queer individuals, chosen family sometimes becomes the only route of accessing companionship, care, and that kind of belonging. So how do you see, from a lens of policy or law, that space can be created for these kinds of diverse family structures that are already existing, or that in lived realities, of course, they have been existing for a while. So how do you see that making up space within the law?
I think, as I said, I mean, contracts are one way to sort of look at that. And why not sort of have, so transgender persons, especially at least hijras in gharanas, these are recognized socially, recognized also legally as per the Nalsa judgment, and very clearly a part of the larger chosen kinship of transgender persons in India, at least to the extent of at least the hijra identity and that subculture, that group of people, you know, within the larger trans umbrella. So yeah, I think recognition is, first of all, for legal recognition, there could be, I mean, the Transgender Persons Protection of Rights Act 2019 doesn't give much hope if you look at the right of, you know, sort of, for example, nominating a kin for a bank account, or these are the things. The Transgender Protection of Rights Act doesn't really provide much of a hope. If you look at the government bureau, the high-powered committee's recommendations of last year, November last year, they have given 4 instructions. These are not recommendations; these are instructions. They've instructed the stakeholders like RBI and others to allow queer couples to open joint accounts. Now, interestingly, the phrase that they have used is queer relationships. They have not used the word couple, if I'm not wrong. So I think that is now therefore a subject of interpretation. Somebody going to a court, a high court, on a litigation, these things would be clarified at some point down the line. So yeah, it is subject to sort of a bit of a progressive realization, I could say, but not that the law is closed on it, not that it's more about the strategic lawyering, if you like, and I think Raghavi could speak more and Kartavi could add to that more. I just wanted to say that there are models of recognition across the world. Belgium is a good model to look at. The Belgian model is about a non-conjugal model. Father and child, a father and son, a son taking care of the father, they're in blood relations, right? But they can be recognized as a as a family, right? So this idea of Belgian, the Belgian law, doesn't work on this idea of couple or non-couple. It doesn't work on conjugal, non-conjugal. It is a person of choice whom you want to call a family. It's a registered form of cohabitation. It's a registered form of relationship, not cohabitation, sorry. It's a registered form of relationship. And so Belgian model can be a good model that can be worked into. Also, the French model is not a bad model, although the French model doesn't allow, the French model has a problem of prohibited degrees of relationship. The French model is totally contract-based. It's called the Pact of Solidarity in English, right? And it has a long French name. So Pact of Solidarity basically means 2 people are free to enter into a contract. They need to notarize the contract. The terms and conditions, like when do you want to exit, at what kind of contingencies the relationship would be considered to be over, what will be the follow-up of a breaking up in a relationship. All of that can be contractually defined in between 2 partners. So I think these are sort of ways to negotiate in the sidelines of the law, in my opinion. But to what extent are we able to do it, I don't know. Yeah. Kartavi, maybe because you have worked on the model family court so intensely, maybe you're the right person.
Yeah, even while working on the code, we looked at a lot of different models and tried to come out with one single thing. But of course, that was also a work in progress, and we thought about how about recognizing marriage, yes, but any other relationship which forms a family as a sort of union in some ways, and divorced from the baggages of marriage, divorced from a lot of things that come up, a lot of burdens that come up with marriage, because that was also a call that came from various quarters from the community, that maybe we don't want marriage to happen, maybe we want a new kind of relationship that we can build on our own societally, socially, over time, which is divorced from the patriarchal, heterosexual mandates of marriage. So yeah, there was a lot of thinking that we needed to do around that. But yeah, legislation is one thing, of course, policy making is one thing, but of course, we also go forward with the courts aspect of it. And as someone who is in courts day in and day out, Raghavi, I would like to hear from you. How do you think this looks going forward, considering the challenge in Suprio field, and how are the courts looking at it? How are we hoping to approach it? How is the community hoping to approach it?
Thank you, Kartavi. So I come from the school of thought where I believe, and I said in my initial comments, that I believe that how we really need to break down the bouquet. We need to take one flower at a time. And why I say that, because as Kartavi also mentioned, that now you have a whole lot of cases and petitions that are going in courts. For example, we have Mr. Desai's petition in Bombay High Court. Then you have Arshia's petition in Delhi High Court that talks about how same-sex couples should be allowed to sign documents and sign papers on behalf of their partner when their partner is in hospital. So, and make decisions, make choices for them. Then you have series of judgments that are coming up in different courts that are talking about these rights separately, the rights that were earlier discussed in court during the Supreme hearing, and it was argued that if the union is recognized, then we'll also get a whole set of these rights. So I really feel that this breaking down has to happen at two levels. One is that we have to take these rights individually to court, and also we need to separate these rights from the sphere, like we are already attempting to separate it from bio-legal sphere. Now we are saying that, or the cis hetero setup, cis hetero idea of marriage, because now we are saying that there are same-sex couples who also demand these rights. But what I also propose is that apart from those couples, apart from limiting this idea of rights to the same-sex couples, we need to extend it beyond, we need to extend it to larger chosen families and to understand them in the set. So for example, why should only my partner have the right to sign papers on my behalf? Why can't it be a person of my choice who is not my partner in the romantic sense, or who is not someone who is not a member of my bio-legal family, but is someone that I put a lot of trust in, or someone who has been with me or around me for a very long time. So for example, Mental Health Act has that exception there. So I come from that place where I feel like that the strategizing has to happen in this way, where in order to talk about the rights, we do not actually restrict ourselves, when we can ask for more, in the sense when we can expand the idea. And it will not only benefit queer people, but it will also benefit people who decide to separate from their bio-legal families for any reason whatsoever. So I feel like the strategizing now, it has to happen in this way. There can be critique and there can be apprehensions regarding that. So for example, the contract aspect also, there are apprehensions, but I feel these are the ideas that are worth exploring. So for example, looking at union as a contract, which is a case in a lot of places, my problem is that understanding how and someone who has worked with the Hijra community, that when they are unable to even go and get their transgender ID card, or when they are unable to get very basic things, the expectation that trans people, because we also need to understand that trans women and trans men are allowed to get into a union, or are allowed to get into the institution of marriage, as long as that marriage restricts itself to the heterosexual relationships. So it has to be a trans woman or a trans man, or a trans woman, a cis man. It has to work in that way. Beyond that, so for example, in my experience of helping people with their documents and other things, I realized that when you go to Aadhaar center to change your Aadhaar card, to change your gender marker in your Aadhaar card, and initially when people were getting their transgender ID cards, and the process also is that you have to go under Section 6 of the Transgender Persons Protection Act, get a TG ID card, which is transgender ID card. Then you move to Section 7, which, if you want to, which is for your gender identity. It recognizes your gender identity. Now, a lot of people at times struggle, because between Section 6 card and Section 7 card, there's a gap, there's time, because these are bureaucratic processes and exercises. And we saw that a lot of people went to Aadhaar center to get some relief. They decided to change their gender to transgender. They did not go for the M or the F marker. And then they realized, then they were told by the Aadhaar center, when they got their Section 7 and they decided that now I should change it from T to F or M, they were told that you can only change your gender marker once. So now, again, this person is stuck in that bureaucratic process where that person is writing to the authority or running post to pillar or has to go for litigation. So again, what I really feel is that there has to be a way where we can eliminate all these bureaucratic exercises to a certain extent, because we have seen with the coming of the TG Act that it has also made people's life very difficult. It was far easier when you had just the judgment, just an Nalsa judgment. You would go to the authorities, get everything done, and now you have a situation where your self-identified gender is recognized, but you go to authority to change your gender marker and they tell you that you need to bring a certificate of surgery, not just medical intervention. So we need to strategize in a way where we have taken into consideration these possibilities and the pain that people go through. And how does it happen? It happens when you take into consideration opinions of people who have experienced these things. When you go to a court, you do not take 4 or 5 litigants who come from a position of class and caste, and they want their rights to be recognized. You also need to take into consideration the ground realities of this country. You have to talk to people across the breadth and length of this nation to see, to understand what different communities go through. So for example, Hijra Gharana, they have their own customary laws that are recognized by court. So their property devolves in a very different manner as compared to how it happens for other people. There is a Guru-Chela relationship that exists. So my only issue being that the strategy has to be in a way where people's voices, lived experience are also taken into consideration. Yeah. Thank you.
Thank you, Raghavi. Certainly, the idea of these rights and entitlements being linked to marriage is certainly from a different era altogether. It's a very like Victorian / Brahminical idea. And of course, a lot of these rights and entitlements have nothing to do with the concept of marriage. Like, what does parenthood models have to do with marriage? We always, despite it always being a prevalent idea, parenthood in India itself has been practiced in different ways. Even in popular culture, I don't know how many younger folks here would have seen the movie Mr. India, and how there is a completely different parenthood model there where a single parent, Anil Kapoor, is looking after a bunch of kids altogether. So of course, there is argument to be made to delink these rights and entitlements, these entire bundle of rights and entitlements from the idea of marriage. But again, how does law make space for it? How does law go about recognizing it is something that we need to contest with going forward and on a day-to-day basis. But also in all of these issues, one of the things that is at the core of it is discrimination and discriminatory treatment. And we have a constitutional guarantee against discrimination, yes, but it often falls short in a lot of ways in terms of the limited number of grounds available, in terms of not addressing indirect discrimination, which is recognized under the under court law, but again there is no statutory recognition for it, or in terms of private discrimination and addressing private discrimination. There's a lot of ways in which it might fall short, and we have these standalone laws that address certain sections of discrimination of certain communities, say the SC/ST Act, the RPWD Act, and now the Transgender Act also more recently. But there is also a case to be made for a comprehensive anti-discrimination law in the same way as South Africa's anti-discrimination law or UK's Equality Act. So I would like to hear from you, Professor Prasoon, what is the scope of an anti-discrimination law in India, and whether there is any scope at all so that a lot of this discrimination gets covered within that comprehensive bucket.
Thank you, Karthik. I think we need a comprehensive anti-discrimination law for the reason that even drawing from comparative jurisprudence and applying indirect discrimination and somehow trying to force fit some of the fundamental choices as being proxy for some of the protected characteristics, it has run its course also the manner in which we are still struggling with the question of intersectionality and not understanding that it has to be a synergetic intersectionality. So we definitely need to move in the direction of a comprehensive anti-discrimination law, but there also I think drawing from the South African experience or the UK experience, we need to build on that, and for that one has to change the logic on which anti-discrimination law functions. The problem is there right now, or even under those laws, if so there can be a list which will allow for maybe a combination of more than 2 grounds, or all of that can be done, but the point is that discrimination is a certain psychology where it is certain choices, no matter how much protection is given, will still be seen as deviant choices. So unless the focus is on the society in general or the discriminator, which is till then the structure of discrimination will not be dented, and that would mean that in addition to the law, one has to look at sociology, look at the theory of stigmatization, and look at new grounds which might not have social history. For instance, a certain body type is something where people face discrimination day in and day out. When it comes to the issue of inking or tattoos, there also it needs to be differentiated as to what is it that one is trying to address through discrimination. And there it would be that any kind of marker where a person has not invested too much value in that marker, but because the society has invested adverse value in that marker, which leads to a position where there is almost permanent low interpersonal status, also there is internalized stigma, and there is structural there is structural stigmatization, as well as beyond that public stigmatization, where one need not even look at law, but in their mind they would think that this is how a person with a stigmatized characteristic is. Unless there is a theory which is based on stigmatization, where all of those labels which are choices of individuals, where it kind of puts people in their place and prevents their mobility in all the spheres, those also have to be included in addition to a very comprehensive anti-discrimination law. And that would mean that we have to look at it as Professor Solanki has said in her book Discrimination and Stigma, that unless we treat discrimination as a virus, where we are not the stigmatized identity is not afflicted by it, but the society is afflicted by it, and treat it in the same manner as a public health crisis, till then this virus is too deep rooted, has already multiplied in thinking through stereotypes, through prejudice. So yes, that kind of effort is needed on all fronts.
Yeah, definitely. I am with you on calling discrimination a virus. I will, let's zoom out a little bit and go back to the case again. And the case, Supriyo, basically, as Raghavi already mentioned, recognized marriage for transgender persons as long as it is heterosexual. So, of course, that misses a lot of nuance for people in relationships, and especially people from the transgender community in relationships. So since you also work with the community a lot, I would like to hear a little bit from you about what the lived experience has been like in terms of, are people really able to register marriages, and not just in terms of being able to, but also what kind of challenges and gaps are faced, be it bureaucracy, be it generally social stigma, and other gaps and challenges that you see might have come up.
Now, a lot of trans people that you talk about who are, so I don't know how many of you are aware, so before I proceed, I'll give you some idea. So a lot of Hijra Gharana, and they are cultural and religious in a lot of sense. They have different practices. So some of them, for example, will allow cohabitation or companionship in the sense, in romantic sense. Some of them prohibit it. So in the context of North, you have Hijra Gharana, and they have different ideas of romantic relationship. Some of them imitate the cis-hetero relationship where you have a man who, in their term, in Hijra Farsi is called Giriya, and then who usually is the masculine, hyper masculine, actually violent person, and then you have the woman, and the relationship usually is a very violent relationship, and you see so many contradictions there, because some of my friends who are really strong, really powerful, they'll pick fights with police walas, they'll not be afraid of anyone, and then they go back home to their giriyas, their partners, and all of a sudden the power dynamics have changed. And during COVID, we saw the reality, and in the sense that the dark reality of it, where you had these giriyas pushing their Hijra partners into doing sex work and forcing them to work to get money so that they can have their desires and their needs addressed. Then you also have another form of relationship which is looked down upon and which is strictly prohibited, which is a Hijra person having relationship with another Hijra person, who they call each other Guru Bhai. So that kind of relationship is strictly prohibited. And then you have people, trans persons, who are outside that Gharana setup. For example, I have never been a part of it. I have interacted, I've spent time with in Gharanas, but I've never made a guru or become a chela of someone. So I don't have that kind of relationship. And then there are a lot of other trans persons, just like me, who do not belong to the Gharanas. Now, ideas of relationship for these people are very different. So that being one. The other aspect is that how transgender identity, so for example, for you to even get your marriage registered, you have to be either a trans woman in a relationship with another man, or a trans man who is in a relationship with another woman. If you are a transgender person, which happened with a lot of people, some did it deliberately because they wanted, they did not want to go for the M or the F binary. Some were gender non-conforming, some were gender fluid, gender non-binary, and that is when we realize that if you are gender non-conforming, or if your gender identity is fluid, you actually cannot can never get your marriage actually registered. So if you look at the definition of transgender persons in the Act, you realize that it's a broad definition with different identities, which include the non-binary identity as well. Now, a non-binary person ideally would not want M or F as their gender marker on their documents. They would, in an ideal situation, would want a TG in their document. But what happens when you take that document to a family court or to SDM's office to get your marriage registered? They deny you registration because it is not allowed. The Act doesn't allow it. The courts do not allow it. And Supreme Court affirmed what was actually held in another judgment, which is Arun Kumar versus Inspector General of Registration of Marriage, which was a Madras High Court judgment that recognized marriage within the Hindu Marriage Act. Section 5, it said that trans woman is a bride under Section 5. So now the thing is that for a whole lot of other identities that fall out of the binary. There is complete erasure, A, of their rights, and B, of their identity as well. Because by limiting the right to a certain binary being in a relationship with the opposite binary, you are restricting rights of so many people. Now that is the marriage aspect. Now coming to the other, as Karthvi also earlier said that post Suprio there were several realizations. I don't think it happened post Suprio. We were just too occupied to not pay attention to other issues, other problems that were there. While coming back also, 3 of us were in a cab and I was talking to a gay guy who faced violence and extortion and the police refused to register an FIR. So there are a whole lot of problems that we never thought of or we never realized we need to address because we were so occupied with the marriage aspect. Rights such as healthcare. So for a lot of trans people, transition is a privilege and we do not understand that. We go on these Instagram page, look at these trans people, compliment them about how beautiful they are, but we do not realize that that beauty is a privilege, that those aesthetic sense are a privilege. How? Because a lot of people cannot afford the procedures that make you feel that this is your body, or they cannot afford the procedures that make you feel aligned to how your inside feels. And that is why we have been advocating for having insurance for trans people to get their medical procedures done. And initially started with the Ayushman Bharat, but now you ask any trans person that have they been able to get their surgery done using an Ayushman Bharat card? No, that doesn't happen. They do not recognize it, they do not accept it. So a whole lot of problems that are there. Another big problem is students who have gotten admission in some prestigious university in US or UK and they cannot go because the passport office is not changing their name or the gender markers in their passport. They are running post to pillar, their Aadhaar card has a different name, different gender. Now they want the same to be in their passport, but the passport office is saying that please get us a sex reassignment surgery certificate. So there are so many problems that trans people and queer people face on regular basis that we don't hear about, that we don't see. It's just a process on the top of the bundle of problems that they already have, dealing with family, there are medical health issues, there are physical health issues, and then you have added responsibility of going to these Kafkaesque offices to get your documents changed. And I know people for whom it took 5 to 6 years to get all their documents aligned. So imagine you are wasting 5 to 6 years of your life doing something that could have been easily done had the government and the policy makers cared about your dignity and about your rights and about your life, your existence itself. So I feel like that along with the whole movement and whole battle for marriage equality, we need to invest resources, we need to support, we need to advocate for these larger rights as well that kind of deal with your daily survival, daily existence. Imagine me entering an airport looking like this and my passport or my ticket having a very different name or a very different gender marker, and then me having to explain that, oh, this is who I am. It's a breach of my privacy also. So I feel like, and puts me in a position where I am vulnerable, and there is a possibility of violence. So I come from a place where I have actually faced all those things. So I think the conversation needs to bring everyone on board. It has to take into consideration these smaller rights? Because with, as I said, with Supriyo also, we might have, had it gone the other way, maybe the right for union would have been recognized. But what follows? That is my question. What followed after Naptej? What followed after Nalsar? What followed after the Transgender Persons Protection Act? We have a whole lot of challenges, and that happens when you do not really talk to the people who have experienced those things, or the people who are going to be at the receiving end of the outcomes of these laws or these policies.
So on that, I think on that note, I mean, it's very important for us to understand why is the TG Act, the Transgender Persons Protection of Rights Act 2019, so problematic. The sections, I mean, there is already a litigation in the Supreme Court, Swati Bidhan Barua versus Union of India, which has challenged different provisions of the TG Act. And Kartavi tells me there is another ongoing petition in the Supreme Court, again, with the same challenge. Now, look, it's because in India we lack pre-legislative consultations. And that's a major problem, because these legislations are not really discussed thoroughly before before the draft bill, you know, is presented by the ministry, tabled in the parliament in one of the houses. You know, the pre-legislative consultations really lack in India. First of all, it's not compulsory, and forget about being compulsory. With the TG Act in particular, we had got 2 private members' bills initially, which were rather relatively better. But then the government came up all of a sudden with this bill, and then this just got passed within, I think, very record time. And that was a problem. Hardly any discussion, even in the parliament. Right? Was it sent to a standing committee? And if it was, then what was the outcome of it? So anyway, and again, the legislative processes also are quite very problematic. We don't send our bills to standing committees again, right? And therefore, the element of conversation, element of having external stakeholders to be able to speak to the lawmaking, authorities, it's just missing. That link is missing. So that is the kind of democracy. We need to change. I mean, as far as that is concerned, because we are a very robust, we should be a very robust democracy. Our constitutional commitment is that, right? We the people of India. So I think that's missing clearly. Otherwise, we will keep having these laws.
Yeah, definitely. We also approach most legislative drafting from the idea that consultation is the essence of any functioning democracy. What is the point of a law if it doesn't account for lived realities? And from that, my last question is again to you, Dr. Mandal, and digging further into that nuance from a sense of intersectionality and power dynamics. While drafting or making policy, one of the fears that the drafter or the policymaker, and something that while we were also working on the code as well as during our superior recommendations, is the law might miss nuance of power dynamics and intersectionality and end up over-regulating what areas that might never need regulation, or that might open up avenues for exploitation that were never existing. So how do you think that accounts, and whether there is a valid fear in that, or the law can just be a bare bone structure? For example, even allowing for contracts or what we call private ordering in family law, the provisions under the Indian Contract Act on coercion or fraud are by themselves also not sufficient when the power dynamics differ that significantly. So how do you see the law dealing with that?
If I got the question correctly, could you rephrase the question, please?
Yeah.
Sorry.
So just from a lens of intersectionality, there is an inherent power dynamic in any relationship. And that power dynamic being accounted for in the process of legislative drafting or policy making, how do you see that happening?
I think you need wider consultations. You need horizontal consultations, and what Vidhi has done with the model family code, there are 2 drafts, the 1.0 and then the second, after a lot of consultation, again a second and a final draft. I think, so that consultation I can tell you, because I was a part of both the rounds, and I can tell you that horizontal consultations took place at different places across India. Stakeholders like academics, activists, lawyers, they all were a part of this, policymakers, politicians. And so And that tells you sort of the stakes the community has in that kind of a draft. It's like a people's draft, right? Similarly, we need more such organizations like Vidhi, so more community conversations on lawmaking processes. And if ministries can take this further, if ministries can sort of, because ministries have the power to sort of draft, they have the means and methods to, means and the logistics to do it. If these consultations are taken by the ministry across, then I think that is again one of the, but at least community support like Vidhi, for example, is doing a great job. So I think that is one way to break the power dynamics, to bring more intersectionality, make your laws more close to the lived realities of the people, which is what is missing, I mean, the TG Act, for example, has this unnecessary under Section 7. There is a bit of clear unnecessary gatekeeping, medical gatekeeping. Yeah. And that, the Supreme Court in Nalsa judgment clearly was against any kind of medical gatekeeping. It was about self-recognition of gender. SRS at all, nothing. I mean, SRS is not mandatory at all in any form or way, as per the Nalsa judgment. But then this particular act sort of, I suppose, as much as I understand, and Raghavi can correct me, it kind of blurs those boundaries a lot. And then the courts end up interpreting things in a different way, bureaucrats interpret it in another way. So I'll end on that.
Thank you, Dr. Mandal. That brings us to the end of the discussion. A very insightful and wonderful discussion. Thank you to all the panelists for joining us, and thank you to everyone for joining us on Friday. I think Utkarsh will take it from here.
After this, I think that was indeed a wonderful session for everybody, and we hope that it was very insightful on the topic that we had for today's panel discussion. After this insightful discussion, I think due to the paucity of time, we can afford to have just 2 questions for the session. So the floor is raised for you guys to ask questions. Who wants to ask a question? Please raise your hands. Does anybody want to ask any questions to the panelists? Right.
Good evening, panelists. My question is to everybody, especially Raghavi ma'am, for the fact that you are practicing in the Supreme Court. Because we've discussed about superior judgment, we've not touched the angle as to how far the judiciary could have gone into the fact in issuing a mandamus to the parliament, saying that you need to recognize the whole fact that marriage as an institution between the queer couple has to be recognized. And secondly, because Professor Satya, he discussed about the fact that marriage is not recognized as a fundamental right. It's only a statutory right recognized under various laws of each community. Therefore, if we give fundamental flavor to the right to marry, do we also then invite further problems by saying that, say, an ex-Hindu who claims parity with his friend who's a Muslim, who, as we say colloquially, enjoys the right to marry 4 women, does then that person claim equality under 14, come in and say that, yes, now I also want equal rights? Or is it merely a statutory right, which is only the domain of parliament to make a law on, and not judiciary to legislate under 141 or under 142?
So I think, and I'm sitting with 2 law professors also, they can correct me, mandamus cannot be issued against like the parliament, and you can't, I mean, then we would have a situation where essentially the court will assume the responsibility of making laws, and they'll keep issuing mandamus, and then you have a country where the actual power is now with the court. So, I mean, I think that just, the brief, it needs brief answer only. It's a settled position also, so.
We have space for one more question. If anybody has any questions, please let us know. This shall be the last question, guys, for today, because we are running short on time. We have to start with the researchers test at 7:30. We appreciate your all cooperation on this.
My query is essentially directed towards the concept that Dr. Mandal talked about. you pointed out how there are cohabitation models and how in those scenarios it is the contractual laws when it comes to a question of separation is looked into. But if we, wouldn't that be the case that if marriage is done away with, if it is the cohabitation model which is looked into even in India, even in that scenario, would it be the right course of law to say that the contractual laws, the commercial laws are looked into when the property or whatever is being divided between a couple? So would you prefer an application of these family laws or a contractual regime?
No, I mean, what I was arguing was basically that marriage already has its remedies under family law. The remedies of a marital family are provided under the family law in the family courts, right? And that's a more humane form of doing it, right? For example, recognizing unpaid labor. For example, a woman's labor is recognized by a family court while granting maintenance after divorce, for example, right? But if it is if a cohabitation under a contract is going to be enforced in a court of law, if that is going to happen, then the court doesn't have the means and the tool sets to apply the humaneness of the family law. But cohabitants are family. Contract law, therefore, is not the right law for family, for cohabitants. It's not the right law. As we have seen the experience in England and Wales, it has not been a great experience with applying cohabitation contracts. One thing that cohabitation contracts can do is a scenario where you don't have to go to a court, where two parties are capable enough, autonomous enough to decide freely. And that is almost an impossible scenario. There is always going to be a power dynamic between the two people in a relationship. One of them would be financially more stable, the other one would be financially dependent at different points of time in their relationship. You know, one person might be doing the household work, for some time the other person would be earning. You know, there will always be a power dynamic and a difference, right? So, you know, this whole idea of contractualizing family law is problematic from that point of view, because there is always a dichotomy between autonomy of the individual and to protect the vulnerable individual in the family, the weaker in the family, right? And to kind of balance the two very conflicting ends of it, contract law somehow is not the right way to go about it. So yeah, theoretically, cohabitation contracts can take two people in a relationship outside the court and to settle the matter outside the court as per the agreed terms and conditions. But if one of them goes to the court and says, hey, I was under undue influence when I signed this contract with you. Now, I mean, there was no free consent at the first place, so this contract has no meaning, and I'm now challenging you in a court. Give me this maintenance. That's that, you know. So then what do you do now? I mean, as a court, you are not a family court. Family law will not apply on you. You will be governed by trust law, property law. I mean, the whole idea will be properties on whose name, who took the loan, who paid the loan, you know, these kind of questions. So yeah, I mean, it's not really fitting unless, I mean, you change the law. What contracts can do is that it's a stopgap arrangement. It's a stopgap arrangement. My advice, or my rather, I mean, somehow, maybe this is I don't know, I mean, if these are workable ideas to what extent, but you know, if there has to be a legislative recognition of cohabitations, first of all, that in itself is a very problematic area. Why should cohabitants be legally regulated, right? Because that is one unit of the family or one unit of the society that is outside the law, right? It was always an outsider in the law, or outsider of the law, and let it be, you know, because legal regulation somehow kills the autonomy, kills the joy, kills the freedom, you know. So yeah, and law comes with its own violence, right? The moment law enters into your domestic space, it enters with its own, you know, tool sets and all. So yeah, what I'm suggesting is that if cohabitation has to be regulated by law, if it has to be, then couples must always have a choice legally to opt out, right? So opting out is sort of recommended by the Law Commission of England and Wales. I'm talking about the 2007 Law Commission report of England and Wales. Opting out is a part of those recommendations. So a cohabiting couple may opt in a cohabitation legal regime, or they choose not to opt into that. If they choose to opt into that regime, then certain rules will apply on them. And most of those rules would mirror, I mean, as per the 2007 regulations, they were mirroring they mirror a bit of the marriage, the heteronormative pattern and framework, right? But yeah, that to an extent can be dealt with, adjusted, and worked upon, right? And England has gone a long way now. I mean, from 2007 to now 2025, things are different. But yeah, but in India, we need that conversation to begin, which they had already begun back then, you know? I mean, this is during the Tony Blair time, the conversations began, and then it continued, right, in the next coalition governments and all that. Thank you. Yeah, please. Sorry? Huh. Yeah. Yeah. Absolutely. Which is the reason, so it's a conundrum, it's a real conundrum, which is why opting out is a way forward probably, gives people the choice to either opt in or never opt into it. But if you opt in, the rule will apply, that's that, right? Then you lose the freedom to contract anymore, right? Also, I mean, given the kind of socio-legal, socio-educational indicators, socio-economic indicators of our society in general, autonomy in contracts is a myth, right? This whole idea of freedom of contract, wo Adam Smith wala idea aise thodi chalta hai. No one is free to contract, it's not at all. You are compelled to sign some contracts, agree to some terms and conditions. There is no choice sometimes. Anyway, let's talk maybe outside, perhaps the time is also short. Thank you.
I think that was indeed a very wonderful session. Thank you, Kartavi. Thank you, Saurav sir. Thank you, Raghavi. Thank you, Satya sir, for joining us today for this panel discussion. I think as we come to the close of this panel discussion, let us carry forward the key ideas and reflection that emerged today. I would also like to thank our audience for their active participation and thought-provoking questions, which added great depth to the dialogue. Thank you again to our panelists, our audience, everybody joining in for making this session a success. Thank you all once again for your time, support, and presence. Thank you so much. We will right now be starting with the researchers test at 7:30 sharp, guys. So whoever is the researcher here, please join us in classroom 1. Thank you. Also, guys, we will be closing the SARC law classroom, so please carry your stuff, otherwise it might get locked inside. So please carry your stuff along. Also, guys, we would appreciate, in case you have taken a water bottle, to carry it back again with you. There's a dustbin right outside. So we would appreciate if you could throw your water bottles. Thank you.